Hi, I'm Eric from Sauce Masters, where we help businesses craft powerful and effective contracts that drive success and protect your interests. Welcome to our free mini course on confidentiality agreements. They're also known as non-disclosure agreements, or NDAs, sometimes also known as proprietary information agreements, or PIAs. They're all the same. We'll cover what they are, how they protect your business. We'll offer a template, show you how to use them, show you what the clauses mean, and then break down legal jargon into something closer to plain English. This is the agenda. We're going to hit all these topics. We'll hit it pretty quick. Your time's valuable, and we want to make sure you are off and running as fast as possible. So we'll cover what an NDA is, we'll cover the why, the purpose, when you might need it, different types, what an NDA typically has. We'll talk about the template that we're offering for free. We'll talk about how to enforce it if something goes wrong, and we'll explain why they're important, why they can protect your business. So let's talk about what an NDA is. It's ultimately a contract. It's a contract that's specifically focusing on your information privacy. Again, they're known as confidentiality agreements. They can also be known as proprietary information agreements. The intent is it's a contract that's meant to protect your information. So it creates a legally enforceable contract that protects, we can call it confidential information. So the purpose, again, is that we have confidentiality. Let's talk about what that means and then how to protect it. So what it means is anything that you declare to be confidential. So you can, in effect, claim anything is confidential, write it down, mark it as confidential, and then you can protect it. How do you protect it? You use the NDA. The NDA is a contract. It's going to have clauses in it, and it's going to tell you and the other person, so that's discloser and recipient, or the other way around if it's bilateral, and we'll get into that. But it does three things. It protects information after you identify it, and then it could potentially protect your intellectual property. So again, it's all about information protection. When do you need an NDA? Well, the short version is anytime you think you need to protect information. So let's reframe that. Anytime information that you share with other people, because in business you typically need the help of others, you need to tell them things, they need to rely on that information so that they can either help you, support you, sell you goods and services. So if you think the information you share with a subcontractor, a supplier, attorney, if you think they disclose it to an unauthorized party and that could impact you, then chances are that's probably confidential information and you probably need to protect it. In those instances, you'll want the protection of an NDA. So some examples: products. If there's something that you make, you're going to sell or license something, you don't want your competition to know, you need to protect your product life cycle, your product launch, you might need an NDA for that. If you have employees, you might want them to sign legal document that protects them from disclosing information to unauthorized sources. That could also apply to business partners or new clients. You take on a new client, you're exploring business opportunities, or you're exploring whether you want to team or collaborate to work on a bid for a client or something, and you're going to be exchanging financial information, technical information, and you may not want that particular client, partner, whoever they might be, to further disclose without your authorization. An NDA is going to help you. Also, mergers and acquisitions, another good example. Those tend to be pretty confidential until they become public. So during the process of M&A or merger and acquisition activity, you might need the protection of an NDA. Let's talk about different types. More common is the bilateral. That is an NDA that covers both you and the other party, and you can share information back and forth. So bilateral effectively means that, back and forth, two ways. Unilateral typically means one way. Well, it always means one way. So if you are the only one disclosing confidential information, such as the pricing of your products, and in that exchange, all you're doing is telling your potential customers what it costs, and you don't want them to further tell anybody because you might be offering them special pricing, as an example, that would be a unilateral NDA. There's also, of course, multi-party, and that might mean you have 3 or more parties as a part of that agreement. I typically don't recommend that on the basis that if you have 3 or more parties, that typically allows you to, again, in some cases, it might make sense where you have to freely exchange sensitive or confidential information between everyone. But in a multi-party, if you're sharing information with Jack and Jill, and those are the second and third parties, if you share your confidential information with Jack, Jack can then share that information with Jill without asking you. And if it's confidential to you, you probably want to know before Jack shares with Jill. So let's talk about the parts of a non-disclosure agreement. In any contract, you have to have certain provisions in order for it to be enforceable, and these are the ones that you have to have. The NDA has to identify who it is between, because it's a contract at the end of the day. It's got to have definitions. This is the definition of confidential information, which effectively you want it to say anything that's marked confidential is considered confidential. There has to be obligations. So what do you have to do? Typically, that's going to be don't disclose to any third party without written consent. Scope is going to be the purpose. Why are you entering into a non-disclosure agreement? Time frame. You've got to, every contract should have a period of performance. It should be time bound. It should have an expiration date. That's what time frame ultimately means in this context. Return of information. So when you enter into an NDA, at some point it's going to expire or the purpose is going to be fulfilled. At that point, what do you do with that confidential information? Best case, you return it. Sometimes you can't, so verification of destruction is typically common and okay and acceptable. There's exclusions. So some information, even though it's confidential, could be in the public domain. So the NDAs typically have an exclusions paragraph that say what type of information is not protected by this agreement. And then finally, remedies. So if there's a breach, if somebody breaks the NDA and discloses unauthorized, well, how can you be made whole? How can you recover? That's what remedies goes into. So we offer a NDA template. This is at no cost. This is intended to help all of the people that we work with, all of the businesses, teams, organizations. We want you to be successful, and we think we can do that through better contracts, helping you improve your contracts, finding where the holes are, where the risks are, and then trying to close those. So we offer this NDA template, and it's sort of a standard. It's got a number of clauses in there, and this template is a good starting point. Now, every engagement, every contract engagement is going to be different, just like your business is different, unique. So what you do with all your different customers can be unique. The intent is to use this template as a starting point. We want to be able to explain what the clauses mean so that you can understand and make tweaks as you need to, but we're always there to offer some guidance and help if you need to. Let's talk about how to enforce an NDA, because once you have it in place, and the template's going to do a really good job of helping you fill in the blanks, put the names here, it's you, it's the other person, your addresses, and then a lot of it is just boilerplate template, but it's very meaningful. But how do you enforce this? If something were to go wrong, if someone were to, let's say, spill the beans, the first thing you want to do is, hey, you spilled the beans. You signed this NDA. I've got to hold you accountable. So identifying the breach is that first step. So that might be monitoring employees. That might be watching who's taking stuff off the printer, reviewing documents, conducting an investigation. Next, if there is a breach and you're convinced, you would send a cease and desist letter. We can help you with that. There's also a lot of templates. You can certainly ask Google. There's a lot of free templates out there. If you've been impacted at this point, you want to seek injunctive relief. That's effectively a special order from the court. It tells people what they have to do or not do. So that's a way to ask a court to, or judge, to step in and help out because you've been impacted. You can then pursue damages. This is where we start to get into claims, legal action, and there's, of course, if you don't want to do that, other ways to resolve a dispute, such as arbitration, mediation. You don't have to litigate because sometimes that carries costs and the juice may not be worth the squeeze there. So NDAs essential to your business because they protect your confidential information. There's a G.I. Joe saying that's knowing is half the battle, and what you know is what runs your business. So having a non-disclosure agreement, utilizing them effectively, they can help you protect your confidential information. So they can help you protect your competitive edge by keeping your valuable information secret to you. NDAs also prevent intellectual property theft because it's a legally binding contract. So therefore, if someone takes your secret sauce, your secret knowledge, and runs off with it, well, they would breach a contract. That's illegal. And they can't do that, or they shouldn't do that. Or if they do that, there's going to be some legal repercussions. There could be financial penalties. There even could be criminal penalties, depending on some cases. But the NDA protects you because they can't further disclose your sensitive or confidential information without getting your permission first in writing. So you might want that. I think NDAs also build trust, because when you create them and you ask people to sign them, your customers, you have a commitment to confidentiality. I think that builds trust. It can also help to attract investors that are probably going to take you a little bit more seriously, because you understand information can be confidential and you know how to protect it and you have written it down. So those are considered policies and procedures, and how you protect other people's information, not just your own, and that's also important. So NDAs ultimately, they provide legal protection for sensitive information, they prevent unauthorized disclosure, and they help you maintain your competitive advantage through doing so. So that's what we have. We're going to jump into the template really soon, just after this, but here at Sauce Masters, again, we try to craft powerful and effective contracts to help businesses. Non-disclosure agreements, or NDAs, that is a form of contract, specifically for your information privacy. There's a lot of other things that we also try to do to help businesses, and that's tailoring contracts so that they meet each business's individual needs, whatever they might be at the time. We also provide comprehensive analysis to look at your existing contracts, look for risks, look for weak language, look for holes where if a contractor or a supplier doesn't perform, it could lead to a dispute, could cost you money, could cost you schedule. We're also very good at what we call language clarity. That's breaking down complex legal jargon into plain, easy to understand English, so that way you understand what the fine print is. We try to do that pretty well so that you understand what you're signing, what you're asking your suppliers or contractors to sign, your clients. We also work with businesses on risk mitigation. So when we look at contracts and we think there's cost risk or schedule risk or technical risk, we try to point it out and offer you could buy down some of those risks or reduce some of that if you add some of this language. We also provide expert support, and we're here to offer guidance, answer questions, provide valuable insights from industry, so ultimately you can feel confident in your agreements and your business decisions. Let's now talk about the NDA template. This is a bilateral template, so it's intended for the sharing of information both ways, from you to someone that you want to share with and from them to you. Our template is a pre-written document. It's got 24 clauses, and the intent is that it's a common denominator. It is a starting point that you can choose your own adventure, fill in the blank. It's going to work for almost anything. So what we're going to do is we're going to run through each of those 24 clauses, and as we said earlier, one of the things we do with businesses is we break down complex legal jargon into something that's a little bit easier to understand. So this free mini course is going to do that in the context of a non-disclosure agreement, and hopefully also give you a template, a tool that you can start using immediately to protect your business, protect your confidential information. Because again, knowing is half the battle. So let's talk about the NDA preamble. This is the first part, first page, top of the document. This effectively says you and somebody else, you'll be disclosing information to one another that could be confidential. It establishes this agreement, this contract. It's a non-disclosure agreement, so therefore it's a contract to protect your information. That's the promise you're making to one another. The first clause that you'll see is the purpose. This really is why you're sharing confidential information. So it could be trying to collaborate on a project. It could be trying to launch or design and launch a new product. That purpose is what you and somebody else ought to agree upon, the intent of the agreement. This second clause effectively means if you share information and it's confidential with another person, with another company, you can protect it by writing it down and marking it as confidential. And even if you share it by talking, that's the verbal piece or oral, or showing someone, visual, you can still protect it by writing a summary, marking that summary as confidential, and then giving it to that person or company within 30 days. That's what that clause means. This particular clause establishes the ground rules for handling it. So it's a very fancy way of saying that both parties, you and the other party, you agree to do your best to keep confidential information private, and you won't share it with anyone who doesn't have a need to know. And you'll only share that confidential information within your own company, your own team, or with affiliated entities if necessary, but only for that intended purpose, which you defined in Clause 1. And the person receiving that information, they can only use it for that purpose. They got to take good care of it, like their own information. And should they need to make copies, they can only do so if it's absolutely needed, and again, to meet the purpose. And they can't try to figure out if there's software involved, how it works, by taking it apart or analyzing it. That's a lot, but that's what this clause says. Clause number 4 establishes ground rules if you need to further share it with advisors or consultants. So let's say you've got confidential information, you want to share it with your attorney, that would fall into this particular clause. So if you receive confidential information, you got to share it with your attorney, you can do so as long as that person, that attorney, has a written agreement with you about the same as this NDA to not further share it. So this clause provides rules on how you can share it with somebody else if you need to, and again, only for that purpose. NDA Clause 5, this is very similar, but instead of just your, let's call it trusted advisors, right? Your CPA, your tax professional, your attorney, your business advisor, that all is kind of covered in this previous clause. Clause number 5 goes a little bit further away from the vest. This talks about subcontractors. So let's say you've got a proprietary design, you're going to have to give it to a subcontractor so that they can make it for you. Same provision. The subcontractor probably has to sign something, special piece of paper. It could be a version of this NDA so that it says they won't tell anyone else. They will protect that information just the same. This clause also says that if you share with that subcontractor and they disclose unauthorized without consent, then the person that you told, who then further told someone, would be liable. This specifically also requires you to list the subcontractors, because if it's your confidential information that somebody is going to share with a subcontractor, you probably want to know with what subcontractor that information of yours is being shared with. So that's what this clause does. Clause number 6 is a period of protection. It says for how long does the confidential information have to be protected. Our template that we offer is 5 years from the date of receipt. So someone tells you or you tell someone confidential information, it's got to be protected for 5 years. We'll get to it, but the period of protection that I just described is different from the term of the agreement, which is really more of an expiration date. And we'll explain that when we get to that. Clause number 7, these are rules in this particular agreement, the NDA, about keeping confidential information safe, but it doesn't apply to certain situations. So these are A, B, C, D, E, and F. These are the certain situations. So if a person who shared the information did give permission for it to be used or told to someone else without any restrictions, or they figured it out on their own, or it was in the public, those are some examples where the rules wouldn't apply, and that's what A through F effectively say. Clause number 8 here effectively says if the government, like the U.S. government or a judge, if they tell you that you have to disclose that information by law, then this clause requires you notify the disclosure of the information. And also, if you intend to tell the government or a judge, no, I'm not going to tell you, it obligates you to notify the disclosure where the confidential information originated from. That's what that means. It also states that if you were to do either of those things, it's not considered breach of the agreement, because in effect the government or a judge or a lawful order was trying to force them to do so, and you don't want to break the law, so you're going to comply. But you've got to tell the disclosure of the information that, hey, I was forced by the government or a judge in order to do that, and I got to let you know. That's what that means. Clause number 9 effectively means the confidential information shared under the protection of this NDA, it still belongs to the person who shared it. So just because you told someone your confidential information, how your software works, it doesn't mean they all of a sudden own it. Clause number 10, this effectively means if there is a piece of paper, something in writing, if it doesn't have a label, if it's not marked as confidential, then you don't have to treat it as confidential. And the whole intent of an NDA is to identify what's confidential, mark it as confidential, and then the protections and the provisions and all these clauses we're talking about, it applies. Clause number 11 effectively says if you need to make copies, you can, but really only to satisfy the purpose. That's again what you defined in clause 1. And if you make copies, those copies have to retain those confidentiality markings. Clause number 12 says before sharing confidential information with any employee or anybody within your organization, like an affiliate, you've got to tell that person, that employee, that they need to keep that information confidential, that they have an obligation to do so. And that employee is not allowed to tell anyone outside the organization that's not directly involved in the purpose. They can't tell their spouse, they can't tell their families. So that's what that means over there. Clause number 13 is a little bit more self-explanatory. It's the points of contact for each POC, point of contact for each company that will do most of the disclosing of confidential information. Clause number 14, this is the term, how long this agreement lasts. It's also, in effect, the expiration date. We typically like to say 1 year. So when you enter into the non-disclosure agreement, it lasts for 1 year. So during that 1 year, anything that you say, that you write down, that you mark as confidential, has to be treated as confidential and protected. Anything that you say, we did say has a period of protection of 5 years. So anything that you say in that 1 year period where that agreement is valid has to then be protected for 5 years. That's how it works. After that 1 year, the NDA expires, all the rules effectively go away. That's what this clause means. Number 15, this means the person who receives the confidential information, they have to stop using it when the agreement ends, or if you tell them to stop. So the person who receives the information after the expiration of the agreement, they should try their best to either destroy all the confidential information that they have, including any copies, or give it back to the person who shared it, whether that's you or you for the other party. And it also says you can keep one copy, just one, for legal purposes, dispute resolution. But hidden data doesn't count. So if your hard drive does automated backups or temporary files, or it's saved in the cloud somewhere and you delete it, but you don't know if there's backups in the cloud because you use just a commercial service provider, that's okay. Number 16 effectively says this agreement is what it is and nothing more. It also says that you don't have to share confidential information with somebody, and when it is shared, it's effectively as is. So you can't, let's say, bet your life on it, so to speak. Clause number 17 effectively means we agree to work together on this particular occasion, but we're not necessarily going to be best friends forever. So the two parties in this agreement, you and somebody else, you're separate businesses. You're working together, but you're not the same company. So each party is responsible to pay its own way, its own expenses related to this agreement. So said another way, you don't have to cover somebody else's costs. This agreement also doesn't mean you're starting a partnership, a joint venture. It doesn't force you to work with them together on other projects. Clause number 18 effectively means if something goes wrong, or even if it doesn't, the laws of what state apply. Generally speaking, you want to pick your home state, the state that your company is incorporated in, and there's also the parties waive any right to a jury trial. Typically, when you enter into dispute over a contract, it tends to be contractual in nature by definition. That tends to get into the realm of business law. Juries tend to be emotional. They tend to be ordinary people for a reason, no bias. But that's not always a good thing when you're talking about business law. You generally want a judge, someone who's trained in law, in order to review the case facts and then render a judgment. So waiving any right to a jury trial means you're not going to be subjected to 12 jurors that will likely, stereotypically, make a decision based on emotions, and instead if it's not a jury trial, then it's going to be a judge, somebody who has a law degree, has gone to different cases where they preside over. They're probably going to make a more judicious decision. Sorry, I digressed on that one. Clause number 19 effectively says the person who receives the confidential information, they've got to follow the laws and rules about exporting things to other countries, if that applies. They're not allowed to just send or sell any technical information or products that they got from you or you got from them to anyone else outside the country without following the appropriate export control laws. Clause number 20 effectively says don't tell anybody about this NDA or that it exists without getting permission first. If you get permission and it's provided, written consent, then you can further share. And that goes for just about anything under an NDA, right? Unauthorized disclosure means you're further disclosing to a third party outside this agreement between you and somebody else without consent or approval to disclose. Clause number 21 means you can't transfer the agreement to somebody else, so both parties in this agreement can't give their rights or responsibilities to somebody else without asking the other party first and getting their permission. So if you want to do that, this clause also says you can't say no without a good reason. That's the shall not be unreasonably withheld part. So you got to be fair about it. Clause number 22, so this means if someone breaks the rules in this agreement, this NDA, or is about to break them, the person who shared the confidential information, who's about to get impacted, they can ask a court for help. They can ask the court to give them special protection or to make the other person stop breaking the rules, and the person who shared the confidential information doesn't have to prove that they were hurt by the rule breaking, and they don't have to pay any money to the court before asking for help. So this is to make sure the rules are followed and the confidential information stays safe. So again, that's what we do here at Sauce Masters. We help break down some of that jargon, which is, again, that jargon does have a place, because in business law, there's a way to construct a legal document. Sometimes it just doesn't make complete sense to the normal person, but that's why we're here. We're here to help. We're here to share our insights. We love the fine print. That's what we kind of live for. So back to the clauses. Clause number 23. This part says if there's any part of the NDA that's found not valid or can't be enforced, it doesn't mean the entire agreement becomes null and void and invalid. So the other parts of the agreement that are still valid, they continue to be followed. So it's like if one piece of a puzzle is missing, but you still have the rest of it and you can put it together, it can still make sense. You can still see what the artwork looks like. Last clause, 24. This basically means this agreement is complete. It's the final agreement between the two parties about sharing and protecting confidential information. More importantly, it replaces any previous discussions or agreements that you might have had about the topic. And if you want to change or add anything to it, you're going to have to agree so in writing and then ultimately sign it. After that clause, there's an NDA signature block. So this is the part where it also says if you sign digitally or by email or faxing, it's the same as if you used pen and paper. But by signing it, it creates a legally and contractually binding relationship. So there you have it. I hope you found this helpful. We walked through all the clauses. The intent there is to break it down, explain it in plain English, because all of these provisions, again, are intended to help your business document what's confidential to you, why it has to be protected, how it's got to be protected, and then the consequences if you don't protect it. That would result in breaching of the NDA, and then you can seek legal action, you can seek injunctive relief, you can send a cease and desist letter. Without an NDA, there would be no rules. And if there are no rules, then that means the rules cannot be broken and you can't be impacted. So again, having an NDA, it protects you. It protects your confidential information and your knowledge, which is power.